officially open, and also welcome officials from Parliament, the support service. The meeting is officially open. Apologies, Alan and Kulek.
Chair, from Standing Committee on Finance, it's only Hill Lewis that sent through an apology.
Lewis.
From the select, sir, we didn't receive any apology.
Okay, no apologies from select committee. And then, okay. Tonight we are meeting to get a briefing from Honorable Shivambu on the South African Reserve Bank Amendment Bill, which is a private member's bill. What I have to indicate is that tonight it is about a briefing on the bill. We'll ask clarity, seeking questions, and make comments. The bill from a private member is treated like any other bill from the department introduced by the minister in most cases. You will remember that in 2012, 2012, there was a constitutional court judgment, case number CCT 1612. It was Mario Ambrosin versus the Speaker of the National Assembly, Honorable Sisulu. The Constitutional Court has made a judgment in this regard that any bill coming from a private member is treated like other bills coming from the executive. So we'll treat it in that manner. Today, we are not going to discuss it clause by clause or also make our opinions, whether we agree or we disagree with the bill. No, like any other bill, the bill will also be taken for public hearings, because we should not, as members of parliament, preempt what the public is going to say about the bill, because otherwise you make a public participation a mockery, and that is not allowed. So the bill will come back after public hearings. We engage with the public submissions. Is then that will go into the discussions as to what is your party view before we adopt the report that will be taken to the House. So I want that to be very clear, because so that tonight we don't go into I've got the party mandate. We're not going to discuss party mandates this evening. That will come right at the end when we are about to adopt the report for the National Assembly. So those of you who will want to go into detail to understand the process, you can look at the parliamentary procedure and also look at the Constitutional Court judgment 1612. It's quite a very long judgment in this regard. It outlines what the private members bill is all about and how it should be treated. So I wanted us to have a clear understanding from the word go that tonight is about briefing, about clarity, seeking questions, and then making comments. But we are not going to deal with clause per clause and disagreeing and agreeing. Comrade Eunice, can you make comments before we request Honorable Shivambu to...
Yeah, Comrade Chair, there's nothing for me to say. You've in fact covered the ground. This matter was raised with me by a member of our committee on the select committee side. And I explained to him, and also spoke to Frank Jenkins, who very much said similar things to what you've said. So you've covered the ground. The only thing the NCOP members need to be aware of is that, yes, it's true, it's an NA member that's introduced a private member's bill, but the effect is the same, as Chairperson you've said, as any other bill from the executive. So it's treated in the same way. We will be with you, Chairperson, and colleagues from the NA side. We'll be with you with the briefings and with the public hearings. And then we will, as we did with the disaster tax relief bills, we will diverge then. We will not engage in the line by line, nor will we, engage on the content of your report. We will obviously be complicit in that, and therefore we can't be independent in terms of our constitutional obligation. So never mind that it's the NA member, in short. And finally, for those of you who are new, if you don't know already, this bill was tabled by Mr. Malema, I think in late 2018. It was one of 4 or 5 bills that we couldn't proceed with, and we said that the new parliament will consider it and they'll be revived. So this bill has a prehistory, if you like, that goes back to, I think, late or third quarter or half. I think it was July or thereafter. I think Mr. Shivambu will explain. So thank you, Chairperson. You've covered the ground very well, if I may say so. There's nothing for me to say. Thank you. But there's one thing, perhaps, Chairperson, I would like to say that, it doesn't matter who introduces a bill. It really doesn't matter. We look at the content of a bill. If there are clauses in the bill, as you said, when we come to it, we agree with, there's no knee-jerk reaction. We look at the merits of it. If it comes from the smallest party, whoever they are, that new party, or whether it comes from one of our own comrades from the ANC, it's not a yeah or there. It's a bill that must be looked at for its merits and demerits. Thank you.
Okay. Thanks, Chairperson, Honorable Karim. Over to you, Honorable Shivambu, to brief the 2 committees on the South African Reserve Bank Amendment Bill.
Sorry, Chair, if I may, before we hand over.
Who's that? Is it Ryder?
Yes, it is, Chair.
Okay, Honorable Ryder.
Thank you, Chair. Noting what the 2 chairpersons have said, unfortunately, my network quality is quite poor, and I cut it out. But I think I got the gist of what you were both saying. Mr. Chair, the fact is that the Select Committee being included in this meeting at this stage is highly problematic for me. Due to the roles of the separate houses, the Select Committee should not engage on the merits of any bill at this stage of the process. Now, while a compromise agreement was reached on the processing of emergency bills, this bill doesn't match those same criteria. And what complicates matters further is that we are here to receive a presentation on a bill that is patently unconstitutional. Essentially, what we're doing is we're giving a grandstanding platform to a flawed position being put forward. So, Mr. Chair, I don't believe that the time of any member is more precious than any other member, but the Portfolio Committee of the National Assembly is extremely competent, and I'm sure that they will have.
We are losing you, Mr. Ryder.
Including the Select Committee at this stage is irregular, and considering an unconstitutional bill through an irregular process cannot be condoned. And I therefore propose that the Select Committee be excused from this meeting.
Chairperson, that's for me to reply to. I don't think we should bring that issue here. I did engage with Mr. Ryder. Firstly, the bill cannot be tabled as I understand it. Frank, if you're here, perhaps you can help, but we shouldn't detain this meeting. The bill cannot be tabled unless it's constitutional. If it was unconstitutional, Mr. Shivambu would have been told how to make it constitutional. He's not a constitutional expert. That's not his job or the job of any member that introduces a bill. That's a separate issue. That's a legal issue between the Constitutional Court, Parliament's law advisors who sanctioned the bill, and the committee, your committee in particular, but our committee too. So at this stage, Chairperson, I think Mr. Ryder is out of order in regard to that. Secondly, because no legal services unit person can allow a private member to submit an unconstitutional bill. They meant to refer it back to the member and say, make it constitutional. So the bill is, according to legal services unit, unconstitutional. The final arbiter, of course, is Constitutional Court. Secondly, I don't think Mr. Shivambu is foolish enough to bring a bill here that in and of itself would be unconstitutional. Thirdly, I really think he has a right not to participate, as I told him. But we are not withdrawing. We've consulted with the Legal Services Unit. We are here, and we would have been here outside of COVID circumstances. This is exactly like any 75 bill. Our committee met and agreed, even before COVID, and he was there, Mr. Ryder, and so were the DA, that we will get briefings and public hearings together, and then we hive off. We've just done that on the disaster management bill, relief bill, tax bill, and Mr. Ryder participated fully. I think we should just now move on. Thank you, Chair. I apologize that the NCOP is inflicting concerns of a particular member. He must go to his lawyers, and he must engage with Parliament's lawyers. His chief would presumably agreed. I think Mr. Shivambu will confirm that in COVID circumstances, this is how we're going to work. There's nothing irregular. So I think that's a matter that's going to do with the joint committees. Mr. Ryder can deal with it offline, not with me, with Parliament's powers that be and the courts. Thank you.
Thanks. The constitutional part of it. No, wait, Honorable Ryder. You can raise the issue. You participate or not, but the constitutional part of it does not arise. Let's take it from there. In 2012, there was a constitutional court hearing. The hearing was on the 7th of August, 2012. The judgment was on the 9th of October, 2012. Case CCT 16/12. It was a matter between Mario Gaspere Oriano Ambrosin, MP, who was an applicant, and the respondent was Maxwell Vuisile Sisulu, Member of Parliament, Speaker of the National Assembly. And there is a judgment, a 71-page judgment. So the constitutional part of it, no. That one I'm not going to take. You can raise the issue of participation, of which the chairperson has clarified. Let's take it from there. The constitutional part does not arise. The bill passes the constitutional muster. It has gone through all the parliamentary processes. That's why it is here. Whether we like the bill or not, that will come at the end when we'll have to compile the report to Parliament. But for now, the member has got the right to introduce the bill and take it to public hearings. So I think let's take it from there. We have done our homework with Honorable Karim even before we came to this meeting. Honorable Ryder.
Thank you very much, Chairperson. Chairperson, I obviously disagree with you. The parliamentary legal advisor goes into to some extent in the introduction of the paperwork that got sent out to make the point that the bill in its current form is unconstitutional. But over and above that, I still believe that the NCOP should not be involved. And as such, Chairperson, I'm going to ask that you excuse me.
Okay. I can't decide on your participation or not. I don't have those powers because it's not like you were out of order, you refused to withdraw, then I say go out of the meeting. Today, we are not going to discuss this. We vote, we amend. We are just listening to Mr. Shivambu as he's introducing the bill. The bill will be taken, and that's where even your members of your political party will engage with the bill through public hearings, and members of the public will also be allowed to make submissions to the committee. You can mobilize as much as you can that the bill be rejected or be accepted. Then at the right time, the bill will come back here and go through all the processes, the NA, the NCOP, and all the, we are not going to short circuit any process. But in regard to the bill being presented tonight, we have done our homework, even with the legal services, with the Honorable Karim, and they have assured us that the private member has got the right to table the bill. But we are not going to discuss content in whether we agree or we disagree. As to whether Mr. Shivambu will take credit or not, that is something else. But as far as I remember, even Honorable Lewis has introduced an amendment bill in regard to PFMA. I will have to check with Alan. And when the time comes, we'll allow Honorable Lewis to present his amendment to this committee. We are not going to short-circuit any process. So what is done to Shivambu today will be done to Lewis tomorrow. Let's apply the rules irrespective of who's introducing whatever subject.
Thank you, Chair. Should I start?
Yeah, I think you should.
Thank you, Chair. You will note that I'll no longer join in the participate in the meeting. Thank you. Good night.
Okay, Honorable.
Honorable Chairperson, Willie Ockham speaking. Can I just have a quick word, please?
Okay, Ockham.
Thank you. Honorable Chair, it's clear to me, and I'm totally in agreement with Honorable Ryder on this. Let's forget about the constitutionality of what the Honorable Shivambu is presenting here. That is a discussion for another day. It is just for me very clear that there are sinister dealings going on in the background. Why are we as the NCOP getting involved in this at this stage? And I know that you've tried to answer that, but I still disagree with you. That is, you are trying to sidestep the processes of Parliament. This should be at the NA at this stage. It should not be in front of the NCOP. And to do something that is unconstitutional or unlawful, and again, trying to put an unlawful or unconstitutional, excuse me, from this meeting as well. As a member of the NCOP, I'll be excused. Thank you.
Okay. But I don't know where's the constitutionality part when members of parliament are being briefed about the bill. Because today we are not going to make any decision which will say that members of NA has forced members of the NCOP to be part of a decision making. Mr. Shivambu is briefing us about the bill that is tabling, which has gone through all the processes. And it's not the first time that the bill is tabled in Parliament. It's just a briefing today, and we'll take the bill through all the normal processes. It will not be tomorrow or next month. We'll allow it to go through proper channels so that whatever decision is taken at the end, no process will have been short-circuited. So I thought tonight we are going to benefit from the briefing that we'll get from the member, because even you are members of the public and members of your political party will want to know what is this bill all about. As a member who is a public representative, you will want to clarify members of your party that the bill is about this and this and that, but as this party we agree or we disagree. But it's not at the stage where we'll take a decision. It's a hearing. Today we're just getting a briefing. I don't know where is the constitutionality about this meeting. We have been having meetings together as the two committees. Why is the constitutionality part being raised today? And the bill will still even come to the processes and come to the NCOP. So where is the problem?
Chairperson, can I just come in here? Chairperson,
at that stage, the NCP is not handling at this
right
stage.
now. Willie, just wait. I'm co-chairing. I would like to now move. I would like to suggest actually to you and to the whole, those who are here, that firstly, if this process is unconstitutional, then so is a litany of bills that have passed through the two houses over many years. When I was on the other side, we also had exactly this process for the last 5 years. Most of the time, briefings and public hearings, Charles de Beer and the committee on that side, including all the TA members, participated. But beyond public hearings, they didn't. There is the experience, Comrade Chair. Right now, we just finished the disaster relief bills. We did exactly the same thing. You will recall I phoned you and said, We won't participate in the last process. I consulted with Frank Jenkins this morning, a lawyer representing the legal services unit, dealing with the finance family of committees, himself confirmed that there's nothing irregular. We are not taking any decisions. It's a nominal briefing and a hearing. Moreover, when the bills come to us, though they be 75 bills, including this one if it gets to us, will actually be dealt with the way we have dealt with things, where we've already advertised for hearings from the fact that you adopted the bill yesterday. Nkululeko has been mandated to advertise for hearings on the disaster relief bills. The same process will apply here. This is not a policy matter. This is a legal matter. If there's a constitutional issue, I suggest that the DA takes it up with the Constitutional Court. It's not for us to sit here. It is now 6:25, Chairperson. It is not a policy matter. It's grandstanding. They did it 2 weeks ago. They did it previous to that. Suddenly today, because they're unhappy with this bill, they're now looking for some excuse that it's unconstitutional. Then their very actions themselves are unconstitutional until now. So I suggest we don't entertain. This is not a policy matter, Chairperson. I would like to move that we proceed with the meeting at 6:25. Let them go to the courts. That's their right.
Chairperson, it's just funny that every time we go to the court, we usually win, and we are then said the ANC then accused us of always going to the court, always going to the court. I've made my point. I do not agree with you. I don't want to waste your time further. If you want to carry on with a unconstitutional or unlawful procedures, it's fine. The fact of the matter is that this bill should not be in front of the NCOP at this stage. If you want to carry on, that is fine. Please excuse me from this meeting. Enjoy your evening. Thank you.
Let's proceed with the meeting. Honorable Shivambu, can you brief the committee about the bill?
No, thank you very much, Chair. And thanks for giving us the opportunity to introduce a private member's bill to the Standing Committee on Finance, which is a standing committee of the National Assembly. That is our understanding in terms of how this process is going to proceed. And just to give clarity to what was the caucus or the seekers of the Democratic Alliance now, we must clarify that we as members of parliament individually can introduce legislation which must be deliberated upon, and then once passed by the National Assembly, it goes through the NCOP process, and then it's taken to the president to sign into an act of parliament. And if the president is not happy about its constitutionality, we'll bring it back to parliament for further deliberations. But also members of parliament individually have got a right and permission to could approach the Constitutional Court to say that whatever is contained in the law that is about to be passed is not consistent with the Constitution. We make that reference in the presentation that we're going to make today here. So the presentation from the beginning, I think that must be clear. We're making it to the Standing Committee on Finance in terms of how it should be in terms of what happens. So we are hereby introducing the South African Reserve Bank Amendment Bill, which will effectively amend the South African Reserve Bank Act number 90 of 1989. So in its current form, the South African Reserve Bank Act allows private individuals, including those who are not resident of South Africa or citizens of South Africa, to own shares of the South African Reserve Bank as shareholders according to the shares that are issued by the South African Reserve Bank and in accordance to the Act. So the private shareholders through acquired shares in terms of the Act have got some role to play in the governance of the South African Reserve Bank, including the election of the directors, but also receiving of dividends from the bank's profits. But we want to state clearly here that our presentation today is thematic. It's about the ownership of the South African Reserve Bank, and I appreciate that there are ongoing debates on the role and independence of the South African Reserve Bank. But we're not dealing with that today. We're only dealing with the ownership component. There are, of course, various authentic and sometimes very correct debates on the mandate of the Reserve Bank and its policy direction. And there's absolutely nothing wrong with whoever is making those contributions in terms of the discourse that relates to the Central Bank of South Africa. And as lawmakers, we have got an obligation and a constitutional right to make laws and oversee the executive. So whatever we're doing here is within our constitutional right. And one thing that we must state from the beginning is that there's no law in South Africa that is cast on stone, that from time to time will engage to amend and change the laws. And even the Constitution, it's not unconstitutional to amend the Constitution itself in terms of what is the mandate of the Reserve Bank and what is its direction. But today, I emphasize again that we're not dealing with that. We're dealing with the aspect that speaks to the issue of ownership. And of course, we are aware that there are so many things that the Reserve Bank that can do in terms of usage of monetary policy to generate a greater economic activity and therefore jobs. We are aware that the Reserve Bank can play an important role in terms of leading the convergence of the macroeconomic policies in the region, in the entire continent, more so that now we've got a ratified Africa Free Trade Agreement area, which will need central banks in the entire continent to play an important role. I think we've already given a clear perspective in terms of the constitutional context that as the National Assembly, as Parliament, we have powers to pass legislations that govern almost every sphere of society. And before we come to the amendments that we are proposing to the South African Reserve Bank Act, we want to just give context as to what is this South African Reserve Bank. So it is a central bank, which is a relatively autonomous financial institution with the monopoly to control the production and distribution of money. It accounts to Parliament. It is currently owned by private individuals. Its role in terms of the Constitution is to protect the value of the currency in the interest of balanced and sustainable economic growth. But in terms of the Financial Sector Regulation Act, which came into effect in 2017, but majority of its aspect operationalized from 2018 forward, the South African Reserve Bank has got an obligation to maintain, promote, and enhance financial stability in South Africa. It is one of the about 9 central banks that have got still private shareholders. The rest of the central banks in the world, more than 240 of those, are state-owned, are owned by governments. And that is why we're coming here to say that we think that it is basic logic, it's basic necessity, it's superior logic that we must have a central bank that is owned by the state. And it has got 2 million shares that have been issued out. And majority, if not all of them, charged at 10 rands. So whoever owns the Central Bank of South Africa today, like if you collectivize the amount of money that has been paid there, doesn't exceed 21 million rands. And I'll give context of what is the importance of emphasizing that. And in terms of the dividend distribution, whenever the central bank has made profits, is that all the profits, even if it's 1.2 or 5 billion rands profits, which the central bank makes out of its dealings with a variety of other business activities, it can only distribute 10 cents per share, which is maximum of 200,000 per year per share in terms of all the shareholders. And in terms of its current architecture and design, there is no single shareholder in the Reserve Bank who can hold more than 10,000 shares, meaning that there is not a single person who can receive shares of more than 1,000 rands on an annual basis. That is what happens. And then the shares and the dividend that remains are then deposited into the National Revenue Fund and to government after the Reserve Bank had settled its own operational expenses and set aside the contingents and reserves and tax obligations that obliges the central bank. That is what it then deals with. And what is the role of the Reserve Bank? It issues banknotes and coins. It prints money. It regulates and supervises financial institutions, particularly banks and the insurance companies and a variety of other role players in the financial sector. It is the one that permits and licenses banks and insurance companies to exist. So there is no bank that exists in South Africa or an insurance company without the permission of the South African Reserve Bank through its prudential authority, which is one of the most important components there. And of course, we'll highlight what are the challenges of that. But it also ensures the effective functioning of the national payment system. It manages the official gold and foreign exchange reserves of the country. It administers the country's remaining exchange control regulations. It is the banker of the South African government. But also, additional to some of the resolutions that were taken in the past, the South African Reserve Bank currently owns 50% of African Bank, an anomaly which, when we have the other discussion about the creation of a state bank, will then deal with that. You cannot be a regulator and a licensor and still be a shareholder of a bank in the manner that the South African Reserve Bank is. And what have been the realities that define the South African Reserve Bank thus far? It presides over one of the most untransformed sectors of the economy in South Africa, which is the financial sector. And of course, I had already indicated that that includes the insurance companies and the banks. And that is what it is. And we know that the banks and insurance companies, majority of them are owned by the white capitalist establishment. So the ownership and control of the banks and the insurance companies does not reflect the demographics of South Africa. And we would know that in South Africa, we still have highest levels of bank ownership and control concentration, with 90% or more of the bank assets being concentrated in 5 of the top South African banks in terms of what happens. But also, the South African Reserve Bank presides over one of the most sophisticated multinational illicit financial flows, tax avoidance, and base erosion. And that is what defines the bank in terms of what happens. But also our observation, and we'll give you a context when we then come to the legislative amendments of what we mean by this, that it largely had been inactive, and it has been toothless because it did not do anything when the banks which it regulates were involved in fixing of the currencies. It led the Competition Commission to be the one that deals with that, whilst they've got the responsibility and obligation to then deal with that aspect. So by and large, the Reserve Bank is responsible for the reproduction of the apartheid economic and financial inequalities in the manner that it is. What is the problem? The problem is one that is observed by, of course, a liberal. It's unfortunate to quote a liberal Prime Minister of Canada in 1935, who said that once a nation parts with the control of its currency and credit, it matters not who makes the nation's laws. Usually, once in control, will wreck any nation until you control the issue of currency and credit is restored to government and recognized as the most sacred responsibility, all talk of sovereignty of parliament and of a democracy is idle and futile. But also one of the most dangerous but very powerful families in the world, the Rothschild, said in their own admission that permit me to issue and control the money of a nation, and I cannot who makes the laws. That is what it is all about. And we have got a situation in South Africa where a significant number of the shareholders of our central bank are not the people of South Africa, and majority are white people, and we know where that come from. And that is basically what it is, that we have a situation that the owners of the central bank do not reflect the demographics of South Africa. And our proposal, the legislation that we're proposing here, is to take the shares, the owners of the Reserve Bank, from the 800 odd private shareholders to 57 million South Africans. That is what we're proposing, that we must change the law in terms of what happens. But also the cornerstone of the ownership and control of the state by the white capitalist establishment has always been the financial sector, has always been the cornerstone of the financial sector through formal and informal influence of the South African Reserve Bank. Leading officials in the financial systems of the country have always been appointed by the capitalist establishment, which is predominantly white, and ownership and shareholding of the SRIB is legitimated through these appointments. And oversight over these private banks, whom through proxies and networks of complex and often illicit ownership is weakened. We have witnessed these as the bank fails to deal with aggressive illicit financial flows and corruption facilitated by the banks. Even when banks are engaged in currency manipulations, which majority of them have admitted, the central banks has failed to act much more decisively. What is the state of central bank ownership globally? There's about 240 central banks that are owned by different owners all over the world. And an absolute majority of central banks are owned by the state as a sole owner, or sometimes with a combination of some private shareholders in terms of what got to happen. And in post-colonial states, more so after the First and more so after the Second World War, a lot of central banks were transferred to the ownership of the state in the manner in which it is. This only 9 out of the 240 central banks that have got private shareholders in the whole world, where and it's not wholly ownership by the private sector. In Belgium, 50% is owned by private individuals, 50% is owned by the state. In Greece, the state owns 35%. In Italy, the state has got no ownership of the central bank. In Japan, the state owns 65%. In San Marino, the state owns 67%. In Switzerland, the state owns 51% of the central bank. In Turkey, the state owns 51%. In the United States, the state owns at a federal level 0%. In South Africa, at all levels, the state has got no ownership and control over the central bank. And that is an issue that we must then deal with. And in terms of the legislation that we have tabled, we have set out basically 3 objectives which are properly articulated in the legislation that is amended and has been availed to all members of parliament who are responsible enough to read, that we are intending to make the state the sole shareholder of the shares of the South African Reserve Bank, and that we must provide for the appointment of the board of directors, the tenure of the office of the appointed directors, and give the minister the power to make regulations related to the appointment of appointed directors. And we must always state that whoever is an elected minister will be doing so on behalf of a democratically elected government, therefore on behalf of the people of South Africa. But also from a technical point of view, that the minister must be given the power to appoint the auditors of the central bank. And specifically, Chair, I'm about to conclude, you'll see now very soon, that the sections that we are proposing must be amended. One is Section 4 of the Act. The current sections provide for shareholders to elect 7 directors of the South African Reserve Bank. So the 13 directors of the South African Reserve Bank and 7 are appointed by these private shareholders. I'll explain who those people are when we're going to the conclusion. And our proposed amendment seeks to empower the minister to appoint the directors of the board and to provide for how the nominations of those directors will be done. And then we're also then dealing with Section 4A of the Act. The current sections provide for submissions of annual financial statements of the bank to be submitted to shareholders. The proposed amendment seeks to provide for annual financial statements to be submitted to the Minister of Finance and Parliament. And then Section 5, 6, and 9 of the Act. The current sections provide tenure and conditions of office of directors elected by shareholders, filling of vacancies, and validity of board decisions. The proposed amendments seek to align the appointment process of the board of directors in line with the state proposal that the state be the sole shareholder of shares of the South African Reserve Bank. And then Section 10 of the Act, we are proposing that there must be an amendment that the current section provides for the bank to form shares. The proposed amendment seeks to remove the power of the bank to form shares as it will be owned by the state. And then we're also proposing an amendment to Section 13 of the Act. The current sections provide for prohibited business that the bank may not engage in. The proposed amendments seek to remove those prohibitions in line with the proposals to make the state the sole shareholder of all the shares of the bank. And then the section, as it is now, Section 13, becomes inconsequential in terms of its provisions. And then Section 21 of the current Act, the current provision provides for the bank to have shares capital of 2 million rand, dividend into 2 million ordinary shares of 1 each rand. The proposed amendments makes the state of the sole holder of shares in the bank and proposes that the rights attached to those shares be exercised by the Minister of Finance on behalf of the state. But we also then deal with Section 30 of the existing South African Reserve Bank Act. The current sections provide for the shareholders to elect 2 firms of public accountants to act during that year as auditors of the bank. The proposed amendment seeks to empower the minister to appoint firms of public accountants to act as auditors of the bank. Then Section 32 and 33 of the Act. The current sections provide for the bank to submit list of shareholders and number of shares held by each shareholder. These sections becomes inconsequential in line with the proposal of the state as a sole shareholder of the bank in terms of what should happen. And what we aim to achieve through a state-owned central bank. The South African Reserve Bank is one of the apex of the financial system in South Africa. And it should be democratically owned by the people as a whole. And if all of us admit that a democratically elected government is a government that belongs to all the people, it must have the right to own a central bank, not a group of individual people in terms of what should happen. But also from a policy perspective, one which we'll deliberate on from time to time is that a state-owned central bank should deal decisively with the concentration of ownership and control in the banking and insurance sector in South Africa. That is one of the issues that we must be unapologetic about in terms of what should happen. It cannot be correct that South Africa, with a population of indigenous people, majority, 80% almost, have got no access to ownership of their own central banks, whilst 90% of countries in the world are owning their own central banks in terms of what happens. Who are these current shareholders whom we want to take the bank from and give to the ownership and control of 57 million South Africans? There's about 802 shareholders of the South African Reserve Bank, and we're saying that let us take from those 800 odd people the bank and give it to 57 million South Africans. And the shareholders of the South African Reserve Bank currently, in terms of the register of the shareholders of the South African Reserve Bank, includes the sitting Minister of Finance, Mr. Tito Mboweni. He has got shares of 10,000 shares. The DA Shadow Minister of Finance, Georgine Hill Lewis, he has got, paltry shares of 10 shares in the South African Reserve Bank. Maybe that is why he is not part of this meeting today, because he knows we're going to be discussing expropriation of the shares from him and give it to the people. It includes the Anton Rupert Trust. It includes the shareholders currently includes Absa Bank Limited, Discovery Limited, which is part of the Remgro Criminal Syndicate, First Rand Bank Limited, which is part of the Remgro Criminal Syndicate. It includes Nedco Limited, which is part of Old Mutual ownership patterns of Trevor Manuel. But it also includes owners from Australia, from Switzerland, from Germany, from the United Kingdom, from Norway, admittedly from Zimbabwe, from Namibia as well. And that is what, in terms of what happens. And admittedly, Chair, there is no massive financial benefits that accrue to the current shareholders of the South African Reserve Bank. So there will never be a sound claim for any compensation that will be unreasonable when we take over the Reserve Bank to state ownership in terms of what should happen. Now, our concrete proposal is that for public purposes and in public interests, which is provided for in Section 25 of the Constitution, we should take the shares of all these owners without compensation. There's no need to do so. It is not going to have any wrong impact. Now, in conclusion, let us dismiss the myths and urban legends that are associated with the nationalization of the South African Reserve Bank. So a lot of right-wing opponents of the nationalization of the Reserve Bank says that it is going to cost South African government billions of rands to nationalize the South African Reserve Bank. That is not the case, because currently each of the 2 million shares is 10 rand, meaning that in total, the shares issued by the South African Reserve Bank is 20 million rand, meaning that no one has paid billions to gain shares of the South African Reserve Bank. It's just a vanity affair, which we must abolish now in the interest of the people. So there is no one rationally who can go and claim billions of rands from anywhere in terms of the nationalization of the Reserve Bank. But also the highest dividend paid to each shareholder annually is not above 1,000 rand. So the people who own like 10,000 shares, which is about 0.5% of the Reserve Bank, they never ever receive more than 1,000 rands as dividends. On what basis are they going to go to court and claim billions of all the assets that belong to the Reserve Bank on the basis that we have taken a correct, properly, politically, morally justifiable decision to have state ownership of the bank? We need to take over the ownership of the Reserve Bank to guarantee true sovereignty and autonomy of our country and parliament in terms of what should happen. And of course, from there on, we'll debate the issue of the mandate of the Reserve Bank and all these issues. Today's discussion is not about the mandate, the role. It's not about how do we use monetary policy to achieve maximal employment, like is the case with many other central banks. Today, we're discussing the ownership component, that there's no necessity, there's no need for private individuals to continue owning private shares in the Reserve Bank. Chair, it is true that what we gained in 1994 of the so-called democratic elections was just transfer of political power, whilst economic power and control remain in the hands of few people. Today, we are presenting an important legislative milestone in the journey that will transform South Africa's economy. Thank you very much. You can see the chairperson. I take in bank.
You can see, Honorable Shivambu. That's a presentation from Honorable Shivambu on the private members bill. Honorable members, Chairperson Karim, let's engage with the discussion. Clarity, seeking questions, and then and also comments. Alan and Kulek, you will assist me in noting members who want to make inputs. Where's the management app? Yeah. Alan and Kulek, can you assist me with members who want to make input?
Chair, there's no request from any member currently.
Okay. So it was loud and clear.
Yeah, it's clear.
Is Advocate Jenkins or Chairperson?
Yeah.
Karim?
Yeah, look, you know, I just wanted to ask a question, right, to Mr. Shivambu. So I know people, even quite high up, Comrade Joe in the ANC, they fully support full state ownership of the Reserve Bank. They agree. When I engage with them, they point out, as indeed do others, who use this as an excuse now, Mr. Shivambu, not talking of those, not to go ahead with this. I'm talking of people who genuinely support it. They say, where's the money? And with COVID-19 now, as you'll know, the argument will be just how are we going to find the money to buy this back? It's based on the presupposition that these people, even though they end up with 1,000 rands, as you say, and the Reserve Bank governor, I think, also says the same, they are going to demand, as indeed one of them I saw in the media, is it a German guy who's controversial, huge amounts of money. He says, yeah, we want it. These people also argue, which I'm sure you're familiar with, that actually they welcome these right-wingers, the EFF's attempt, and in fact, the ANC in Nasrec, as you well know, took that decision. They welcomed this because they can make a killing, so to speak, financially. So I'm talking about people who are genuinely wanting this, not those who are using it as an excuse that they ain't the money. So what makes you so convinced that you can buy it for what its value actually is, taking into account the ceiling of dividend they get 1,000 rands? What makes you so sure about that? Secondly, are there legal issues that arise? I know you're not a lawyer. It's a matter, Chairperson, we as a committee and joint committees have to address. So for example, is there some legal means to say, within the current dispensation, legal, that, hey, you know what, you're only getting 1,000 rands within a month. Let's go to court, and the court will decide that you cannot demand millions and millions to make a killing out of a reserve bank. You get the drift, Mr. Shivambu? This will come up sooner or later in the processing of the bill. So I raise it now. Thank you.
Thanks, Chairperson. Are there other members who want to make comments and ask questions?
Chair.
Okay. In the meantime, can you respond to the?
Chair, like I'm trying to, like, I don't know which rational court anywhere in the world. Not even under Mnangagwa, who has got like a lot of, I don't know which regional court can say, you have spent 100,000 rands to pay 10,000 shares of the Reserve Bank. And for the rest of your life, in terms of the current legislation, you can never receive more than 1,000 rand in dividends. And then you go to court and say, I'm claiming billions in compensation when we take those shares. Where is the just and equitable component which is contained in the Constitution? Because you must remember that when Section 25, outside of the land question, it deals with property in general, that in public interest and for public purposes, you can expropriate sometimes without compensation. That if there's ever going to be compensation, it must be just and equitable. I don't think that there's any rational court that can ever claim compensation that says all the gold reserves of the Reserve Bank and all its assets, everything else that it has, must be compensated to private individuals. It will be irrational. Then it will be pure madness in the manner that it is. So these things are just used as scarecrows. And the ruling party must appreciate that the establishment handed you power so that, and with an undertone that you must not have any control over the economy. That is why every day they get an opportunity. They say privatize this, privatize this, privatize this. It is starting now with state-owned companies and Reserve Bank and everything else. The next thing they're going to tell you that privatize the police because you don't know how to do policing. Privatize all schools. You must just give us the money, just go and collect revenue. They'll tell you to privatize everything and you will not have any public responsibility, and you know what are the consequences of privatized entities. So these scarecrows that are being spread all over there is just about maintaining the wide control of a very important component of the economy. And there are so many things which the Reserve Bank is not doing, which normally was supposed to be dealing with. Like, how do you explain that you have the levels of concentration that we have now in terms of bank ownership? The Reserve Bank knows very well that at operational level, banks deliberately profile black people and charge them more interest rates and everything else. They've got the power to could say, from a regulatory point of view, you cannot do that, but there's no consequences. The banks have admitted themselves that they were involved in fixing of monetary policy. That is a fact that once you get involved in forex issues and what is the value of the rand, you are even overcoming the role of the South African Reserve Bank. And these are the banks that they regulate, but nothing was done about it. It was just left as a competition commission issue and no consequences, which are like significant on those particular banks. So these things that is going to be claims of huge amounts of money and everything else there is just a scarecrow to frighten a black government from control of its own resources. Of course, there will be challenges and mistakes and a variety of things. That is why when we then deal with legislation, we must then be detailed in terms of how then do we protect the central bank in a manner that will not be subject to abuse, like some of the state-owned companies are. And that will be dealt with when we then deal with the further detail of the bank, because I'm sure that part of the public hearings will be, what are you going to do to prevent what is happening in Transnet or SA8 from happening in the Reserve Bank? Then we must then strengthen our legislative instruments to prevent that from happening. That is the perspective that we must always look into. Thank you.
Thanks, Honorable Shivambu. Honorable Digaledi Mahlangu, are you struggling to connect, or you are raising a hand to participate?
No, Chair, she has problems with connection.
Oh, okay. Do we still have members who want to ask questions or make comments?
No, Chair.
Before I request the legal division to clarify us about the process from here. If not, is it Sister Tebo, who is that? Who's there? Nolutando. Nolutando Pikash, are you here?
Yes, Chair, I am here.
Can you take us through as to from here where to? Over to you, Nolutando.
Thank you, Chair, and good evening to you and good evening to all the members that are in the meeting today. Chair, my name is Nolutando Mpikashe. I am the parliamentary legal advisor that assisted Mr. Malema in drafting the bill, and I'll also be advising the committee on the South African Reserve Bank Amendment Bill. Chair, it is important to note that in terms of Rule 279 of the National Assembly, subsection 4, it is provided that a bill that is introduced by a committee or an assembly member must be accompanied by a report or a legal opinion from a parliamentary advisor that the bill is consistent with the Constitution and that the bill is consistent with existing legislation and that the bill is drafted properly in the form and style which conforms to legislative drafting practice. Chair, we have certified that the bill is consistent with existing legislation, taking into account the South African Reserve Bank Amendment Bill. It intends to amend the South African Reserve Bank Act of 1989 and is properly drafted in the form and style which conforms to legislative drafting practice. However, Chair, we have a constitutional concern related to the bill as it is currently presented before the committee. As a result, in terms of Rule 279.5, we have provided an opinion which accompanies the bill in terms of, as I'm saying, in terms of Rule 279.5 on why the bill is not being certified as constitutional. Chair, I will read from the opinion that we have presented to Mr. Julius Malema. I will read the opinion, Chair, as it is just to, for record purposes. I am going to share the opinion which we did to the Honorable Mr. Malema. We are first gonna read from paragraph 4 of the opinion. I'm not gonna go to the previous paragraphs because they are not related to the issue at hand. Section 21 of the South African Reserve Bank provides that the share capital of the South African Reserve Bank shall be 2 million rand and shall be divided into 2 million ordinary shares of 1 rand each. The bill seeks to amend this section by making the state the sole shareholder of the shares in the bank. The effect of the amendment is that the shares currently held by the shareholders would be expropriated by the state. The bill is silent on whether the existing shareholders would be compensated for their shares. We advise Mr. Malema that a transitional provision is required to provide for the transfer of shares in accordance with Chapter 2 of the Constitution of the Republic of South Africa, specifically Section 25. Our instructions, however, indicated that expropriation of these shares should be without compensation. Section 25 of the Constitution provides as follows. No one may be deprived of property except in terms of law of general application. And no law may permit arbitrary deprivation of property. Property may be expropriated only in terms of law of general application for a public purpose or in the public interest, and subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to by those affected or decided or approved by a court. The amount of the compensation and the time and manner of payment must be just and equitable, reflecting an equitable balance between the public interest and the interest of those affected, having regard to all the relevant circumstances, including the current use of the property, the history of the acquisition and use of the property, the market value of the property, the extent of direct state investment and subsidy in the acquisition and beneficial capital improvement of the property. And the purpose of the expropriation. For the purposes of this section, the public interest includes the nation's commitment to land reform and to reforms to bring about equitable access to all South Africa's natural resources, and property is not limited to land. The starting point then would be to establish whether shares in the Reserve Bank constitute property within the meaning of Section 25 of the Constitution. Section 25(4) provides that for the purposes of Section 25, property is not limited to land. In the case of First National Bank of South Africa Limited versus the Commissioner for the South African Revenue Services and another, the Constitutional Court did not attempt to a comprehensive definition of property, saying that the exercise would be practically impossible and judicially unwise. The Constitutional Court stated in the First National Bank case that ownership of a corporeal movable, which in this case was a car, was a right clearly at the heart of the constitutional concept of property, both as regards to the nature of the right as well as the object of the right, and must therefore, in principle, enjoy the protection of Section 25 of the Constitution. And the Bill of Rights Handbook, Kevin Iles argues that the inclusion of personal rights within the term property is not surprising. A great deal of private wealth consists of personal rights, shares, unit trusts, private pension, benefits, etc. In Law Society of South Africa, this is Minister for Transport, the Constitutional Court stated that the definition of property for purposes of constitutional protection should not be too wide to make legislative regulation impracticable, and not too narrow to render the protection of property of little worth. It is clear from the above discussion that our constitutional jurisprudence accepts that property is not only limited to land. Thus, it is our submission that the shares in the bank constitute property within the meaning of Section 25 of the Constitution. And now I'm going to move in and discuss deprivation of property. Deprivation of property is permissible according to Section 25(1) of the Constitution, provided that it is not arbitrary and is carried out in terms of law of general application. As stated before, the effect of the bill is that the shares will be owned solely by the state, thus depriving the existing shareholders of those shares. The Constitutional Court held in the First National Bank case, which we mentioned above, that a deprivation of property is arbitrary when the law does not provide sufficient reason for the particular regulatory deprivation, or when it is procedurally unfair. The complexity of relations must be considered in testing whether there is sufficient reason for the regulatory deprivation. The more extensive the deprivation and the stronger the property interest, the more compelling the state's purpose has to be for having the regulatory deprivation in question in place. The aim of this bill is to nationalize the Reserve Bank and make it state-owned. This, in our view, is persuasive enough to render the deprivation of property non-arbitrary. So in this instance, I would argue that the deprivation envisaged by the bill will further be done in terms of law of general application. Thus, the deprivation aspect of Section 25 the bill would pass its constitutional muster. But when it comes to expropriation, it's a different story, which we are going to discuss below. In the First National Bank case, the Constitutional Court stated that the expropriation is a subset of deprivation. Interpreting the term expropriation in Huxley versus Lane, the Constitutional Court indicated that expropriation for purposes of Section 28(3) of the interim Constitution, which is an equivalent of Section 25 of the current Constitution, means the compulsory acquisition of rights, property, by a public authority. For expropriation to have taken place, the state must acquire the substance or core content of what the property owner was deprived of in order for deprivation to constitute expropriation. Judge Nkabinde in the Reflect All case versus the MEC for Public Transport Road and Works in the Gauteng Provincial Government stated that, I quote, although it is tried that the Constitution and its attendant reform legislation must be interpreted purposefully, courts should be cautious not to extend the meaning of expropriation to situations where the deprivation does not have the effect of the property being acquired by the state. As I have said, the state has not acquired the applicant's land as envisaged in Section 25.2 and 25.3 of the Constitution. For that reason, no compensation need to be paid. Close quote. Based on the above discussion, it is our submission that to deprive the existing shareholders of their shares in the bank and for the state to acquire those shares constitute expropriation. The bill, as stated before, is silent on the compensation of those shares to the existing shareholders. In terms of Section 25.2 of the Constitution, expropriation is only permissible for public purposes or in the interest of public. Secondly, an expropriation is subject to payment of compensation for the property that has been expropriated. The principle of compensation as a requirement for expropriation was discussed by the Constitutional Court under the interim constitution in the Hudson versus Lane case, where Judge Goldstone stated, I quote, Section 28.3 sets out further requirements which need to be met for expropriation, namely that the expropriation must be for public purpose and against payment of compensation, close quote. The Constitutional Court in Agri, South Africa versus the Minister of Minerals and Energy confirmed what it said in Hudson versus Lane. In that case, the court stated, I quote, whereas expropriation entails state acquisition of that property in the public interest and must always be accompanied by compensation, close quote. Consequently, based on the above Constitutional Court findings, the expropriation envisaged by the bill must be accompanied by compensation. The Constitution requires the compensation to be just and equitable in its amount, timing, and in the manner of payment, but does not provide an explanation of what just and equitable compensation actually means. There are guidelines developed by our courts and a list of factors in the Constitution that must be taken into account by the courts when determining what is just and equitable. Even with these guidelines and factors, the meaning of just and equitable. Even with these guidelines and factors, the meaning of just and equitable is so vague that it is very difficult to predict what a court will determine as just and equitable on a case-by-case basis. Section 25.3 requires that a balance be struck between the public interest and the interest of those affected by the expropriation. In attempting to strike this balance, the Constitution directs courts to take into account all relevant factors. In this regard, also see the discussion below on Shabati versus FIC, where the court found that it is just and equitable for compensation to be nil. We will discuss that further below. The Constitutional Court held in Mohan Ram and another versus National Director of Public Prosecutions and another, and that a lack of discretion on the part of the court to forfeit property would result in an arbitrary deprivation of property. The expropriation of shares envisaged by the bill is not immune from the requirements imposed by Section 25 of the Constitution. Where provision is made for compensation, a court could find that it would be just and equitable for compensation to be nil, but this would be after a careful consideration of all the relevant factors. If the bill is passed as is, that would mean that there is no discretion given to courts and thus no opportunity for the interest of the shareholders to be balanced against public interest. This would infringe the rights of the shareholders under Section 25 of the Constitution. The state would be required to show that the infringement of that right is a justifiable limitation in terms of Section 36 of the Constitution. there are two distinct views from the legal scholars on whether Section 25 of the Constitution could be limited successfully under Section 36 or not. The rights in the Constitution are not absolute. Section 36 provides that the rights in the Bill of Rights may be limited, but only in terms of law of general application, to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all the relevant factors, including the nature of the right, the importance and purpose of the limitation, the nature and extent of the limitation, the relationship between the limitation and its purpose, and if there are any restrictive means to achieve the purpose. Judge Ackerman stated in the First National Bank case, neither the text nor the purpose of Section 36 suggests that any rights in the Bill of Rights are excluded from the limitation under Section 36 of the Constitution. Further, Section 25(8) of the Constitution is explicit in making Section 36 applicable to Section 25. The limitation clause applies generally to all the rights in the Bill of Rights. If considering the bill, the court would apply a two-stage approach. It will first determine whether the right in Section 25 has in fact been infringed. We are of the view that the lack of a provision to provide for a consideration of compensation infringes Section 25(2), and accordingly the state would be required to show that the infringement is a justifiable limitation of that right in Stage 2. This entails showing that the criteria set out in Section 36 are satisfied. Some legal scholars, like Kevin Alf, argue that the difficulty with this two-stage analysis is that it makes the basis for justifying the infringement of Section 25, the very reason why Section 25 was infringed in the first place. For example, where Section 25(2) is infringed by expropriation by means other than the law of general application, or where the infringement or an explanation, it was not for a public purpose, or it was not in the public interest, or that an expropriation without just and equitable compensation. Section 25 requires compensation for an expropriation to be fair and equitable in amount, timing, and manner of payment. Compensation that does not meet this requirement can hardly be considered reasonable and justifiable. Excuse me. It seems then that Section 36 can have no meaningful application to Section 25 of the Constitution. Alves argues that the right in Section 25 of the Constitution have been qualified to such an extent that it is unlikely that any violation of those rights can be justified. The limitation of Section 25(2) has not been tested in the Constitutional Court. If the bill is challenged and the court follows this view, then the bill will not pass constitutional muster. The second view, shared by the Land Claims Court, is that the general limitation provision of Section 36 and the specific limitation provisions of Section 25 apply cumulatively. The Land Claims Court in the Nhlabati case that I said we are going to discuss below applied Section 36 to the infringement of Section 25 of the Constitution. The Land Claims Court in that case held that legislation granting a right to a family member of a deceased occupier to bury a deceased on the land they occupied was an uncompensated expropriation of property. The court went on to hold that the legislation was a justifiable limitation of Section 25(3). The statutory obligation of a landowner to allow an occupier to appropriate a gravesite of his land without receiving compensation was found to be a minimal interference with the property right and necessary to protect important cultural and religious interests. The court therefore found that it was just and equitable for a compensation to be nil. However, if the Constitutional Court applies the Nhlabati reasoning and judgment, we are of the view that the bill would still fall short of being justified in terms of Section 36 of the Constitution. The sections in Esther that the court considered in Nhlabati envisaged a prior relationship between the owner of the land and the deceased, as the occupier, including prior permission from the owner or reasonable conditions set out by the owner, thus envisaging a balance between the rights of the beneficiary and that of the person who is being deprived of property. Also considering how the courts have emphasized compensation when expropriation takes place, it is unlikely that the court will find the limitation of Section 25 by the bill, especially as the bill does not even allow a discretion to the court to award compensation at a nil value, justifiable in an open and democratic society based on human dignity, equality, and freedom after taking into account all the relevant factors as listed in Section 36 of the Constitution. The Constitution in this case was specifically considered for its relevance to the subject matter and compared to the contents of the bill. We are of the opinion that the bill may not pass constitutional muster if it is passed as is, as the proposed expropriation of shares does not allow any discretion for the consideration of compensation, which is contrary to what Section 25 of the Constitution requires. Whether the infringement could be justified or not as a Section 36 limitation is a gray area which still needs to be tested and clarified by the Constitutional Court. In conclusion, the bill in the context of the Constitution as it stands currently may not pass constitutional muster and we will not be able to issue a certificate. However, it is important to note that it does not stop the committee from processing the bill. As the chairperson correctly pointed out at the beginning of this meeting, that private members have a right to introduce bills in Parliament, and Parliament must consider and process those bills. It is also important to mention before I stop talking, Chairperson, that the bill, as it is in front of the committee, can still be amended on the instructions of the committee to cater for the expropriation. Because what we are saying is that at least, even if the court says the compensation could be nil, at least give the court the power to make that determination. The bill must not just be silent on that, because then we are just opening the bill to constitutional challenge. And that is the advice that we would give to the committee. And thank you, Chairperson.
Thank you, Ms. Nolutando Pikachu. I just want to check something here. Are we now dealing with the finality of whether, when we take the bill back to the National Assembly or to the House, we think it won't be constitutional, or now we are at the stage where we have got the briefing, we have to take the bill to the public, for the public to make inputs through public hearings, submissions, and so on and so on. I think we need clarity. At the same time, we have got a bill that we are dealing with on expropriation of land without compensation. How is that constitutional? That process is constitutional. This one we think won't be constitutional. Ms. Pikachu, how do we treat the two? Because you are referring to Section 25, and even the land expropriation is dealing with amending Section 25. How do we deal with that? Let me ask those questions, and also invite Honorable Karim to ask you the question. I know Honorable Shivambu is burning to say something, but we'll come to him.
Thank you, Chairperson.
Can I just come in, Nolutando, playing my role as a chairperson now? So firstly, I'm not, you see, the co-chairperson is correct. Now, perhaps you can help us, and then Mr. Shivambu can reply. I think the policy issues raised in the bill need to be addressed. It's there in NASREC as well, right? So that's not the issue, Mr. Shivambu. It's simply, I don't understand, Comrade Chair and colleagues. Are you saying Mr. Malema and Mr. If so, you can't have the speaker refer it to a committee. The speaker cannot refer to us in terms of Parliament's rules, as I know. On the stage. To the minister concerned and say, can you make it constitutionally sound? And the lawyers of the minister and the lawyers of the state law advisor who are dealing with a bill will make it constitutional. Similarly here, this is not the responsibility of a portfolio committee more than it is with the minister's bill. It's between constitutional, in which case, can you all sort this out? Because it will be inappropriate for any committee in Parliament to proceed with what is unconstitutional. Or are you saying, the second thing, are you saying you think it may be unconstitutional? In which case, you're certifying it for now. Case law that you have, it could or it couldn't be unconstitutional, and therefore let the bill go ahead and let it be referred, as has happened in some cases, chairperson and colleagues, especially new colleagues, to a constitutional court. Now, as I understand the rules in Olutando, nothing stops Parliament Speaker from saying, okay, we passed this bill and we want to refer it to the Constitutional Court to have the say even before we give it to the president. So, in short, are you saying the bill is unconstitutional? If so, why do you certify it for the speaker to refer to us? Or B, are you saying you're not sure about its constitutionality? The committee can go ahead and then let the court decide. That's the question to the lawyer. The question to Mr. Shivambu. Shouldn't you, as behoves any minister, ensure that you're on safe ground? The policy issues remain. In what way, if you were to make a safeguard to ensure that it meets the requirements of Nolutando and her team in Parliament, would it undermine your policy issues? I would imagine any member who's bringing a bill doesn't want to end up on the court and get stuck there and constant things. So let's leave this separately from the DA's behavior. That's separate. This is a legal matter. It's not for our two committees, your committee in the first instance, Comrade Joe, or our committee to deal with constitutionality. That can be sorted out, Mr. Malema, Mr. Shivambu, and Nolutando and the team. Thanks. So the question is one to Malema, what's the name, Shivambu? The first question is not to the lawyer. What is she really saying? It's not clear to me.
Can we make interventions, Chair? I think, like, I don't know, like, this is actually the most unprocedural and unlawful thing that ever happened in this process. Parliament deliberates on many legislations, and the issue of constitutionality of any bill is at the latter end of it. It doesn't happen at the beginning. It has never happened anyway. Even the Constitution is very clear in terms of how legislation is dealt with. We introduce legislation here, we deliberate on it as Parliament. And if different political parties and different members of Parliament think that it's unconstitutional, state that in the committee deliberations. And then we'll go to the House. If you reject it, it's okay. If it passes the House, you still have to persuade the president that don't sign that into an act of Parliament because it's unconstitutional. Then you'll bring it back. And if that is not the case, you still have an option of going to the Constitutional Court. So this one of trying to pass a judgment, what the lawyer was saying now is just an opinion. I can come with an opinion tomorrow that says exactly directly opposite what she's saying now. It's an opinion, it's not a judgment. There's no parliamentary legal advisor who has got a right to stop any bill from being tabled at Parliament. It doesn't exist anywhere in the rules. So the bill is introduced. Let's go through the parliamentary process. If Any political party thinks it's unconstitutional, vote against it in the committee, vote against it in the national parliament, vote against it in the NCOP. Write the president and say, no, please don't sign because you are the one who ultimately signs off these bills into law. If the president refuses, then go to the Constitutional Court, then we'll meet there to illustrate that this is, so to then deal with it, you are putting the cart before the horse, and it's unacceptable. We are falling into the trap of class interests who do not even want to have a deliberation on things that undermine their class agenda. It cannot be. It cannot be. You cannot hijack a process like that. You cannot allow that to happen. Let's deliberate on the bill, and if you've got a problem, we'll meet in the process that follows afterward. That is how law is made in South Africa. Not to say, no, before you even introduce the bill, it's not constitutional. There's no such a thing. There's no rule, there's no law that deals with that. No way.
Okay. Noluthando, do you want to comment before I take the process forward?
Yes, Chairperson, let me answer the questions that were raised by yourself and Honorable Mr. Karim. Chairperson, the bill was introduced in Parliament, and the Ambrosini judgment that you mentioned before doesn't say that a bill must be constitutional before a member can introduce it to Parliament. And which is why I mentioned the rules of the National Assembly. And normally when there's a private member's bill or a committee bill in front of the committee, the person who drafted the bill or the unit with his legislative drafting unit would come to the committee and say that they certify that the bill is constitutional. In this case, we are saying we are concerned that the bill, if challenged, might be unconstitutional. Remember, Chair, we are not the Constitutional Court. They are the final arbiter on constitutional issues. We just give an opinion and we quote, as you have seen when I was presenting the opinion. We look at previous judgments and form an opinion based on that. And as Honorable Shivambu is saying, someone might come and say, and quote also cases and say that the bill would actually pass constitutional muster. So it is for the committee then to decide whether to proceed with the bill after the advice that they were given by the parliamentary legal advisor. Remember, there must still be a motion of desirability. In the opinion that I was reading before, we mentioned that the constitutionality of the bill might actually affect the motion of desirability, but it is up to the committee to say that we want to proceed with this bill. And then someone will take it to court, and then the court will decide on the bill. We are just stating this is our opinion. And as Honorable Karim was asking, why would a speaker refer an unconstitutional bill to a committee? The bills, when they introduce in Parliament, especially the private members' bill, Parliament has a duty, which is stated by the Constitutional Court in the Ambrosini case, to process those bills and for the parliamentary process to continue. And it is up to Parliament to decide whether to pass a bill or not. I think the questions.
Chairperson, can I come in? Because look, this matter is before the NA and ultimately it's your committee's decision. Therefore, I don't want to come in after you now because you have to suggest a way forward. All I can tell you is that if Noluthando is saying that they think the bill could be unconstitutional, point one, it could be unconstitutional, they're not sure, then in that case, it seems to me that will be appropriate for the committees to process it. If that's what you're saying, that is a view they have, that it's it may be unconstitutional. Then it seems to me that the committee can proceed with the bill. If she is saying it is unconstitutional, then the issue becomes, why do they certify for the speaker to refer it to us? The second point is, if Mr. Shivambu, there's a question to him that perhaps he might or might not want to answer because not answerable to an NCOP committee chair. but perhaps it's something you'll want to think about, because we want to deal with the policy issues, Mr. Shivambu. There is no issue. There's no excuse here. He can do whatever he wants to say or think. It's his right. It's a democracy. There's no like roundabout way of dismissing the issues. It's on our agenda as the ANC anyway. So, Mr. Shivambu, all I can suggest to you is, if it means you have to tweak your bill slightly to be safer on constitutional grounds, and then they say, look, now they're more confident. If it doesn't undermine any policy you're trying to seek to achieve, you and your party, I would suggest you do it. The point about being...
We'll never do that, Chair.
That's fine.
So that
Sure,
never happen.
dealing with now...
Your request will never be accepted too.
I am a coach person, you know the rules. Never mind.
But also, your request will never be accepted too. You're part of the law.
That's all right. But the right.
Part of the past law that you try to divert us.
You must
I
control
agree with you.
It is not above the rules of parliament. I am now chairing opportunity to I put to him. Right. Now on the procedure matter, I am a chair of a committee. He must listen or leave the meeting. Now, here it is. As a chair of a committee.
Honorable committee. Hello, Honorable Shivambu.
I'm not a chairperson of a committee. No, as a chairperson of the committee, I have a right. Right. This is it. This is it.
I'm a member of this committee.
Can you control your member?
Honorable Shivambu.
Now, here's the issue. If the speaker has referred it to us, this is a matter that can be easily resolved. That means her office and her legal advisors, presumably, have looked at this bill. They presumably think the latter, that Nolotando is saying, we're not saying the bill is unconstitutional. The bill may be unconstitutional. We've advised Mr. Malema, Mr. Shivambu, they don't want to make the change, which is their right. She is saying, moreover, that the Constitutional Court did not explicitly say that if a private member brings a bill, it has to be constitutional. Presumably A, because like any bill that comes to Parliament, they presume it will be constitutional, or B, they think that the bill can be brought to Parliament even though it may be unconstitutional, and as long as the Speaker and the NCOP chair refer it to the respective committees in their respective houses, it's allowed. So that's a matter that should be sorted out outside this meeting, offline, between the committee chairs, the committee chair in particular, and the EFF, and actually the lawyers. It's not a matter for us to sit here. We're not lawyers. Mr. Trump doesn't have to answer anything. I'm addressing Nolotando. I had a suggestion to him. He doesn't have to agree to it. But I'm addressing the point.
Okay. Wait a bit, Honorable Shivambu. I'll come back to you.
I'm addressing Nolotando.
Yes. Let's take Nolotando, then we'll come back to you, Shivambu. Can you rest? Be calm. So that we're dealing with a very serious matter, and we don't want to be seen like we're stifling democracy. We just want this matter to be threshed out so that when we leave here...
It's not you. It's a class racial agenda. I'll tell you about it now.
Okay. Let me take Nolotando.
What's the race issue here? The class issue. You the racist, not me.
Okay, Honorable Karim, let's take so that we take this matter to finality.
Thank you, Chair. Chair, as the Legal Services of Parliament, we are of the view that the bill as is, if challenged, will not pass constitutional muster. We are not the final arbiter to say the bill now is unconstitutional. We are just giving a view, looking at previous court decisions and looking at how Section 25 is currently in the Constitution. Hence, there is a process to amend Section 25 of the Constitution, because currently Section 25 of the Constitution does not allow expropriation without compensation. So now we are saying until the Constitution is amended to allow expropriation without compensation, we are of the view that currently the bill is in violation of Section 25 of the Constitution. It is a view of legal services. We are not, as I said, we are not the final arbiter. We cannot decide what is unconstitutional and what is constitutional. only the courts have that right to decide what is constitutional and not constitutional. We just give a view and offer a view to the committee. It's up to the committee to take our advice or not to take our advice, as much as it is up to the member that we draft a bill for to take our advice and not to take our advice. Thank you, Chair.
Okay, thanks. Over to you, Honorable Shivambu.
Chair, don't fall into a trap of a pre-planned agenda. The current constitution clearly states in section 25 that for public purpose and in public interest, you can expropriate without compensation, right? In terms of that happens, then there's an issue which we're dealing with in the other committee of the Constitutional Review Committee that wants to then deal with the detail of that. And it has never happened since 1994 that you prevent a bill from being presented in Parliament because of an opinion of Parliamentary Legal Office. It has never happened. What happens is that we process a bill, and then once the bill has been processed, it goes to all the houses. If the ANC wants to vote against it, go and vote against it. Why do you want to preclude democratic engagement? Let's debate the bill in the committee. Let's take it to the National Assembly. If your view is that it's unconstitutional, state that in the committee deliberations. State that in Parliament. Vote against it. Not to preclude it from it being debated here. We are not going to withdraw the bill because we believe it's a constitutional bill. It complies with all the necessary mechanisms. You have got all sorts of recourse. You can refuse in the committee. You can refuse in the House. You can tell your president to sign against it. You can go to court. But now you want to prevent us from debating a necessary legislative amendment on the basis of an opinion which has got no legal standing. Nowhere in the rules of Parliament that anyone can stop a bill from being of an opinion of higher staff of the ANC in Parliament. There's never been there. Oh. Don't fall into the trap, Chairperson. This is how these people operate. The reason why I said in the beginning that I'm presiding the Standing Committee on Finance, I knew it because Yunus Karim has been brought back to try to divert the attention of this particular bill. And don't fall into the trap.
Okay, wait.
Nonsense from this chap.
Okay.
Chairperson, can you control your member? He must behave.
Yes.
Too much of latitude. No bill from a minister can be presented to Parliament if it has not been constitutionally certified. He's telling lies. He is lying. He is lying. No bill in Parliament has ever been tabled which has not been certified.
Okay. Honorable Shivambu and Honorable Karim. Let's finish my point. Can I finish my point? Yes, but make sure that you finish my point.
As long as it's not abusive, Chair, I won't allow it. It can be abusive. You must deal with the
focus on the
we deliberately said we must go and listen to the opening remarks that we're presenting a bill because we know how bills are introduced. Are introduced in a standing committee or portfolio committee of Parliament, right? But because they want to manage you, then they said it must be a joint committee. If this joint committee is going to do these things of Yunus Karim trying to interfere with us, he was voted out of the National Assembly.
No.
Let us convene the Standing Committee of Defense.
Honorable Shivambu, please.
Let's because you can see that James to divert us from what we're focusing on now. And we will never agree to that.
Let's focus on what Noluthando has raised so that I'm able to say this is how we should move forward. and forget about you discussing Honorable Karim and a whole range of other issues which are side issues. Yeah, let's come back and focus on the process. You have got connectivity problem, Honorable Shivambu. Can you assist?
I don't have connectivity problem. I don't have someone is muting me. I'm saying that there is nowhere in the Constitution, there is nowhere in the rules of Parliament that says that you can prevent a bill from being presented because of those concerns. Because of we deliberate on bills, if the constitutional issue has to be dealt with, it will be dealt with at the ultimate. That is the process of Parliament, which we are supposed to respect in terms of this process. And can we, Chair, in conclusion, convene a standing committee of people who are elected as members of Parliament, not people who are appointed like Yunus Karim, and let's have us who are elected to come and deliberate on this issue, and then we'll then take it to the NCOP to then deal with if it needs their attention. But it currently doesn't need their attention.
No, let's leave the personalities and deal with the process. Noluthando, it is the office of the Speaker who has referred this bill to this committee. How did it come, as Honorable Karim has asked the question before, that yourselves who also advise the Speaker, we believe, have allowed the bill to be where it is now? Then when it is at the committee, then you say it's unconstitutional. Why didn't you find a way before the Speaker referred it to the committee to stop it there? Because now you are putting us in a very difficult position. We don't want to be seen like we're stifling democracy. Why was the bill allowed to come here?
Thank you, Chair. Chair, the rules of Parliament allow members to introduce bills. And the rules of Parliament also say that a bill must be certified by a parliamentary chief law advisor or by a person that is designated by the chief parliamentary advisor. Then it goes on to say that if the parliamentary advisor is of the view that the bill is unconstitutional, they must issue an opinion to that effect to say that they of the view that the bill is unconstitutional. However, the rules do not say then that Parliament can then not proceed with the bill, because, Chairperson, the member has a right in terms of the Constitution to introduce a private member's bill. And we are here to say whether the bill is constitutional or not. But as I said, Chairperson, it is our view, we give an opinion. We cannot, as parliamentary legal advisors, say definitely that a bill is unconstitutional. The courts have to do that. We cannot do that, as much as the Speaker can also not do that. It's just an opinion that we present to the committee. It is up to the committee to accept that opinion or to agree with our opinion or not to agree with the opinion. It is not just because we said the bill, we are of the view that the bill is unconstitutional. Now the Speaker has to say that the member cannot introduce that bill, because members have a right to introduce bills in terms of the Constitution. Thank you, Chair.
But did this bill go through all the processes of Parliament, even through the office of the Speaker, to be right here today at the committee?
That is correct, Chair. And the bill, as the rule says, the bill has always been accompanied by this opinion that we have provided. That's all the rule says, that you must give an opinion. It doesn't say that the member must then be forced to withdraw the bill, or the Speaker cannot allow for the bill to be processed in Parliament.
Has the Speaker been informed or consulted?
It's not going to be.
Yes, Chair. When the bill is introduced, it goes to the Speaker's office. The process is that the bill goes to the Speaker's office, and then it goes to then the Speaker refers it to a committee after introduction to Parliament. So the Speaker is aware of this bill. The Speaker is aware of the certificate. The Speaker is aware of the opinion that was provided to the member, and the opinion was made available to the speaker. And the reason we are raising this opinion now is that we could not certify the bill as constitutional. Since I've worked in Parliament, I've never seen an executive bill where the state law advisor has said that the bill is unconstitutional. Normally, when you're drafting or when the bill comes before the bill comes to Parliament, you would say that the bill is unconstitutional, and then the department would try and resolve the constitutionality issues, which is what is our role is. But then it is up to the member to the policy is sorry, Chair. The policy or the sponsor of the bill, it is still the member. We are just here to guide and assist Parliament, but we are not the final arbiter in determining what is constitutional and what is not constitutional. The courts have to do that. So in other words, the Parliament has a duty to process bills whether we are of the view that they are unconstitutional or not. Thank you, Chair.
Okay. In a situation like this, as a committee, we don't want to be seen like we are stifling democracy. And as I've said before, if I'm not mistaken, there is also a bill that will come with Honorable Lewis on the amendment of the PFMA. And we'll also allow that bill to be presented to this committee, like the SIRB Amendment Act, Amendment Bill. I think we should allow the normal process of processing the bill to go ahead, for the bill to go to the next process. I'm not sure what is the public hearings or public submissions, go through all the processes, come back to the committee, we debate it, make party presentations that as DA, as Freedom Front, as ANC, as EFF, this is our view on the bill. Have the report before the committee, adopt or reject the report. I think we should allow the bill to go through the normal processes and let it be at the end like other bills. I remember there was a land, I'm not sure whether it was an amendment bill, which was bringing an issue of a cutoff date to be not, instead of 1913, to go beyond 1913. That bill was passed by Parliament, but courts raised an issue about a whole range of other issues that the committee didn't follow properly. I'm not sure where is that bill now. So I will say, Honorable Karim, my co-chairperson and honorable members, to me, it will be proper that we allow parliamentary democracy to take its course, allow the bill to go to the next step, and then go through all the normal processes. And then at the end, the legality will sort itself out, whether the public reject it or accept it. If somebody takes it to the Constitutional Court certifies it or reject it, that is something else. But I think for now, let's allow the parliamentary democracy to take its course without, like, it's seen like as the committee, we are stifling the process. Because for now, as individuals and as party members, we don't have a view as to whether we reject or we accept the bill, but we are following the parliamentary process. And I would like that in all the bills that are presented, whether from the executive or from private members, we follow the same process to the latter, so that it's not like we have got a predetermined outcome of any other bill. That will be my view, Honorable Karim, before I come to the last item of closing the meeting.
Chair, can I just finish? I'm co-chairing. Look, it's very simple. The decision about whether to proceed with the bill is not a joint decision. It's a 75 bill. It's the NA decision. Up till this moment, NCOP members can participate. Whatever Mr. Shivambu says, he's not above the rules. Now, that's between him and the powers that be, nothing to do with me. So that decision can only be made by the NA committee. We will participate in the public hearings if that's what your committee decides. Then only if the NCOP chair refers it to us do we proceed. The same issue would apply as Mr. Shivambu raised here. It'll be raised there, which is that once it's tabled to us, if it's correct what Nolotando says, that whether a bill is constitutional or not, unlike in an executive member's bill, a member can go ahead, then so be it. That's all we saw, clarity. The same will apply to us. We are bound by the same rules. So if your committee is going ahead with it, and it's legally tenable, the process, and then it's referred to the NCOP chair, and then it's referred to us, we will proceed with it too. Thank you. There's nothing further to say from my side as a chair. Thank you.
Okay.
Chairperson.
Hello. Is it Shivambu?
Yes.
Okay, Honorable Bushbaum,
Chair.
come to the last item. No,
This bill, it doesn't involve. Chairperson, am I on the platform?
yes.
This bill is a Section 75 bill. It does not involve the National Council of Provinces. I'm putting a position here which is constitutionally and rules-based, that it must be the Standing Committee on Finance that processes the bill until its conclusion. Because I can see that there's a sponsored infiltration of the committee by class and racial interests. That they're taking deliberations here. Those who are in the NCOP, they've got certain rules and certain. This is not one of them. Let's meet at the Standing Committee on Finance to deliberate on these things without the infiltration that is being sponsored. And you could see by the list of people who are here that is the same group that controls national treasury that we have raised concerns about before, that they want to divert attention. They thought that we're going to concede into their demands that we can't table this bill. We can't do that. The bill must be processed strictly by the committee, not by some infiltrants who have been sponsored to come and divert the attention of the committee. We've got a bill before the committee. It must be deliberated upon. It must be concluded. Ines Karim and his friends, let them go to court and challenge that.
Honorable Bushbaum, let's deal with.
You can't allow this sort of drivel, Chairperson. You're not behaving, Chairperson. He's talking utter nonsense. I was dealing with the legal issues. He's talking utter nonsense, actually.
Honorable
drivel. We've just met as joint committees all the time. What he is saying is outrageous. And he should be called to order.
The bill
he talked
doesn't involve you.
He's not even a
you are an appointed member of parliament.
It makes no difference. There are two houses, and I have been appointed, like your members are also appointed. You don't like the Constitution? Tough, change it. But for now, I'm here. Live with it. I'm not answerable to him. He's answerable to Parliament. So I said, we will not interfere in your decision. If the NCOP chair refers this to us, once the speakers process the matter via you, we will deal with it like any other bill. But he can't dictate to us either. Thank you. I don't want to hear his dribble. Can you please I will reply, Chairperson, if you allow him to talk his nonsense. He's racist, anti-class, anti-Marxist nonsense.
Okay.
I'm not going to have it, Chairperson. No, not from this little nipper.
Okay, no, thanks. Honorable Shivambu, let's focus on the process. Let's not focus on attacking other colleagues. Let's focus on the process. We got the legal opinion. And you heard what Ms. Mpikash has said in regard. She said it's an opinion. It's not a decision that we can't go ahead with the process. For now, I want us to focus on taking the bill to the next step. That's what we should focus on. Let's not attack other members and we divert what we're discussing. So let's focus on from here. This is the process that we are going to take. Pikachu will have to advise that under normal circumstances, once we have got the briefing, because the position where you are, if it was not you, if it was not the private member's bill, it would have been a minister briefing the committee. So after a minister or a private member briefs the committee, what is the next process, Noluthando? Hello, Ms. Pikash.
Yes, Chair, I'm here.
After a minister, if it's a bill that comes from the cabinet, briefs the committee about the bill, and now it is the private member, what is supposed to be the next step?
The next step should normally the bill is advertised for public hearings, for public submission. Sorry, Chair. That would be the next step.
Okay. I think we should go to the next step, like we treat any other bill, and then get input from the public. So let's take it in that manner, and then we'll deal with a whole range of other issues as and when they come. I'm sorry, it's just that the debate ended up becoming clashes between members. It's quite unfortunate. It shouldn't have happened. We should have focused strictly on the bill and the process which the parliamentary advisor was outlining. So what you are saying, Noluthando, from here, the bill will have to be taken to the public. There will be adverts and a whole range of other processes that are supposed to be followed. So I think let's treat the bill in that manner. You will work closely with the Secretariat, Alan, and others who are part of the committee Secretariat to treat the bill like any other bill. Our views will come at the end when we have to deal with clause by clause, voting, and probably debating in the House. I think we are done with the briefing.
No, thank you very much. Thank you very much for your thorough guidance, Chair.
Okay, you can see Shivambu. Alan and Kululeko, are there, what do we call, what is this item before closure?
Announcements.
Announcements.
Other than tomorrow's meeting at 12 o'clock, Chair, it's a briefing by National Treasury on the Audit Professions Amendment Bill. That's all I wanted to announce.
Okay, so our next meeting is tomorrow at 12 o'clock. Thanks, honorable members. Good night. Enkosi, Akensa, Bayadanki, thank you. See you tomorrow at 12. Bye.
Bye, Sisalo.
No, see.
Hi, Sisalo. Good day. Are you fine?
Very fine. The chairperson must always be cool-headed, otherwise the meeting can collapse.
Yeah. I found you sweating there.
You know, when you deal with your colleagues, it's not easy. You try to reconcile and.
Yeah, I know. Otherwise, the study group that side went well and left, but I was
Oh, they are small business. Okay. I was attending the ETC. It started. I left at 5 to 6.
Oh, okay.
But one had convened an ETC at 5, so I rushed to ETC at for 55 minutes and came.
Oh, okay.
Yeah.
In fact, even there, the advice I gave was for us to convene a sanitary group with Enoch to address the issue of banks needs them. Okay, Chair,
And
right.
man.